Hello, in this video, we're going to discuss the first year class Civil Procedure, or as I'm sure you're going to call it very quickly, Civ Pro. There's two parts to Civ Pro, and your school may or may not divide these two parts into two different classes. At my school, we took 2 semesters of Civ Pro, and we had one of these parts each semester, or they may combine it all into one class, and you take all of Civ Pro in one single semester. The first part of Civ Pro is case-based. So this is going to be a lot like your other first year classes where you're reading cases, briefing cases, dissecting cases, and talking about the court's holdings. The other half of civil procedure is rule-based. There's a set of rules called the Federal Rules of Civil Procedure. And in that part of the class, you're going to be going through these rules and discussing how they apply. So this may be a class that you don't have a lot of familiarity with, and you may be thinking, what exactly is civil procedure? Well, civil procedure are the procedural rules that apply to litigation. Litigation is any time you have a court case where the parties are disputing one another. So the civil procedure rules tell us things like which court to file in, where to file, how to file, what to file. They tell us about different motions and what types of motions can be brought at certain times. There are rules regarding timing, so the schedule of how litigation proceeds. One thing that can make this a really tough class as a first-year law student is you likely don't have a lot of exposure to the court system at this point. And so you're going to be learning a lot of rules and terminology and vocab, but unfortunately, you may or may not have a lot of context to apply these things to at this point. So it's important to pay attention not only to the facts of the cases in Civ Pro, because it'll help give some context to some of these confusing rules and issues, but also think about Civ Pro in the context of your other classes. When you're reading cases for torts or criminal law or contracts even, think about the civil procedure implications of those cases as well, because civil procedure applies to all civil litigation. So anytime you have a contracts case, a torts case, those are all civil lawsuits, and the civil procedure rules will apply. So we're going to start by talking about the case law-based part of civil procedure. So this does not come from those federal rules of civil procedure that I mentioned. This is going to come from case law. So the courts have decided these doctrines. And the first thing we're going to talk about is jurisdiction and venue. Jurisdiction in this context is a fancy word for power. And jurisdiction looks at the court's power to hear a particular type of case or hear a particular case. So we're asking ourselves, can this court hear this case? Do they have the power to hear the case? There are 2 types of jurisdiction, and in order to hear a particular case, the court has to have both types of jurisdiction. Number 1, they have to have personal jurisdiction, and this is all about fairness to the defendant. Personal jurisdiction answers the question whether the court can hear the case over this particular defendant. Now, the defendant is the person being sued, and so the plaintiff has chosen to file the lawsuit. So we don't really care about the plaintiff in this context because the plaintiff is agreeing to this lawsuit where they chose to file the lawsuit. So this is really just focused on the defendant and whether it's fair for this defendant to be hauled into this particular court and have to defend him or herself or itself, if it's an entity, in this particular court. In order to see if there is personal jurisdiction over a defendant, we start with general personal jurisdiction. Now, there are certain places where a court can hear any type of case over a defendant, and that's what we call general personal jurisdiction, meaning that the court has power generally to handle cases involving this person or defendant. So first thing you want to do is see if the court has general personal jurisdiction. There are 3 methods for obtaining general personal jurisdiction over a defendant. Number 1 is consent. So a defendant could consent to being sued in a particular place. This could happen, for instance, if a defendant had signed a contract and the contract included a provision indicating which court would hear the dispute should one arise from that contract. This occurs in a lot of boilerplate contracts. You've probably signed a contract with, let's say, a cell phone provider that indicates that a particular jurisdiction or state will have the power to hear any breach of contract litigation that comes up between you and the cell phone provider with regard to that contract. That means you have consented by signing the contract to be sued in whatever state the contract specifies. That would be considered express consent. Implied consent could be if the defendant is sued in a particular court and doesn't object. So for instance, if I live in Michigan, but let's say someone files a lawsuit against me in Texas, and I get the complaint, I find out I've been sued in Texas, and I simply answer the complaint, and I respond to the allegations in the complaint. And at no point do I say, hey, you know what? Texas doesn't have jurisdiction over me. I can't be sued here. If I don't object, I am impliedly consenting. So either way, that state gains jurisdiction over that defendant. That's method number one, that a state can get general personal jurisdiction. Method number two is presence, and there's two ways to get presence. Number one is continuous and systematic contacts with the state. So I mentioned that I live in Michigan. Let's say, for instance, that I live on the border between Michigan and Ohio. And even though my house is in Michigan, I work in Ohio. So every day I get in my car and I drive to Ohio, and I spend a good chunk of my day in Ohio. And I'm there almost every single day for work. I likely have such continuous and systematic contacts with Ohio that it's as if I live there, and that might be enough to say that I am present in Ohio for purposes of personal jurisdiction. And if that is the case, then Ohio would have general personal jurisdiction over me, meaning that someone could file a lawsuit against me in Ohio for anything. The other way to get presence as a means of general personal jurisdiction is if the person is present in the state when they are served with process. We'll talk about serving process. It's one of the rules of civil procedure, but this is the procedure that occurs when someone hands you the summons and complaint, letting you know that you've been sued. So if, for instance, I live in Michigan, but I was in Florida on vacation, and while I was in Florida, someone came up to me and handed me a summons and complaint for a lawsuit that had been filed in Florida. My presence in Florida at the time that I was served would be sufficient to say that Florida has general personal jurisdiction over me. And now Florida has the power to hear that case over me, or at least they meet the personal jurisdiction aspect of it. The third method of acquiring general personal jurisdiction is domicile. You can be sued in the state in which you are domiciled for anything, even if the lawsuit arises from outside the state. So if I was to go to Florida, for instance, on vacation and get into a car accident while I was in Florida, the other person in the car accident might want to sue me. I live in Michigan. My domicile is Michigan. So that plaintiff in Florida could come to Michigan and file a lawsuit in Michigan with regard to that Florida car accident. And Michigan would have jurisdiction over me as a defendant because I am domiciled in Michigan. This is the easiest way to get personal jurisdiction, is to simply sue the defendant in the state in which they are domiciled, because there's no question that the state in which they live has the power to hear cases that are brought against that person or entity. So where is a person domiciled? Well, this may seem kind of obvious, but sometimes it's a little bit tricky. A person is domiciled in the state that is his or her permanent home, where they intend to stay indefinitely. So if my, let's say, permanent home is Michigan, but I have a vacation home in Florida, Michigan is my domicile. A person can only have one domicile. My domicile is not split between Michigan and Florida. My domicile is just Michigan, and that's it. A corporation, on the other hand, can have two domiciles. A corporation is domiciled, number one, in the state where it's incorporated. This is where they file their paperwork to be a corporation. So you just look to see where they filed their paperwork, and that's considered a domicile of the corporation. And then number two, they have a domicile where their principal place of business or headquarters is located. And that may not be the same state. Lots of corporations incorporate in Delaware so that they can have a domicile in Delaware, but then their headquarters is somewhere else entirely. So those corporations would have two domiciles, one in Delaware and one wherever their corporation headquarters is. And so a corporation may have one if it's the same place, or they could have two. So if there is no general personal jurisdiction, so if there was no consent, there's no presence, and we can't establish a domicile, or if we want to file somewhere other than the person or corporation's domicile, our second option is to look to see if there is a court with specific personal jurisdiction over this defendant. Now, unlike general personal jurisdiction, where the defendant could be sued for literally anything, specific jurisdiction means that the lawsuit has to be related to the contacts with the state. So for instance, if I live in Michigan, but I'm in Florida going on vacation, and I get into a car accident while I'm in Florida, and someone wants to sue me for negligence arising out of that car accident, the car accident took place in Florida, so my contact with the state and being in the car accident is directly related to my lawsuit for negligence arising out of the car accident. In order for a court to have specific personal jurisdiction, it has to be constitutional. It has to meet the Due Process Clause of the Constitution, and there are actually two requirements. In order for there to be specific personal jurisdiction, the U.S. Constitution has to confer jurisdiction, and we'll talk about the test to make sure that it's present in just a minute, and the state constitution has to confer jurisdiction. Almost every state has enacted what we call a long-arm statute, and the long-arm statute dictates when that state has the power to execute personal jurisdiction over a particular defendant. So to see if a personal jurisdiction is constitutional at a state level, you look at the long-arm statute. To see if personal jurisdiction is constitutional on the federal level, the Supreme Court has developed a test for us to use to question whether due process has been met. And the test that we look at to see if a specific personal jurisdiction is constitutional is what we refer to as the minimum contacts test. So are there sufficient minimum contacts between the defendant and the state so as not to offend traditional notions of fair play and substantial justice? This test comes from the International Shoe case. That's where the Supreme Court developed this test that we now use all the time to determine whether specific personal jurisdiction is constitutional. So you simply look at the contacts that the person has with the state. So for instance, that car accident example, my contact with the state was that I got in a car and I drove the car on the Florida roads. It's fair to hold me responsible in Florida for my conduct driving my car on the road in Florida. So that would likely satisfy that minimum contacts test. And Florida would have specific personal jurisdiction over me with regard to a lawsuit arising out of a car accident. Now, as I said, the contacts have to be related to the lawsuit. So if someone was suing me, let's say for breach of contract, that had nothing to do with the state of Florida, but I just happened to be in Florida at one point on vacation, they can't sue me in Florida and say, well, you were in Florida one time in your life, so Florida has contacts with you. No, the contacts have to be related to the lawsuit. I am quite sure you're going to read a number of cases in which the court has interpreted and analyzed and dissected that minimum contacts test. Some of those cases are listed here for you. For instance, the first one is Worldwide Volkswagen versus Woodson. So in this case, what happened was a couple had bought a car in New York, and they were going to be driving that car across the country, and the car broke down in Oklahoma, and they wanted to sue the dealership, saying that the dealership sold them a faulty car. Well, the dealership's in New York. And so the court looked at the dealership's contacts with the state of Oklahoma. And the court said that that car dealership did not purposely avail itself of the privileges and protections of Oklahoma law. Because how would they have known that this New York family was going to be driving their car across the country, let alone that they should expect the car to break down in Oklahoma and then expect to be sued in Oklahoma. So the court said that Oklahoma did not have personal jurisdiction over that New York car dealership. Now, that doesn't mean that this is the end of the line for that family. That just means that the family has to find another court that does have power before they can sue that car dealership. For instance, if the car dealership is incorporated in New York, the family could very easily go to New York and file their lawsuit in New York. Without a doubt, New York has personal jurisdiction over that New York car dealership. This is just saying that Oklahoma does not have the power to hear this type of case over this particular defendant. Another case you're likely going to look at is the Burger King case. So in this case, it was actually a Michigan resident. So there was a man in Michigan who contracted with Burger King, which at the time had its headquarters in Florida, to open up a Burger King franchise. This man had never been to Florida. He never went to Florida. He never visited Florida. All of his transactions were done electronically. With the headquarters in Florida, he signed the contract in Michigan. But he had this contract with this company headquartered in Florida. So in that instance, contrast that with the Volkswagen case. In the Burger King instance, the man knew. He knew exactly what he was doing. He knew he was going into business with a Florida corporation. And so when the contract was breached and Florida brought a lawsuit against him in Florida, he had purposely availed himself of the benefits and protections of Florida. And so it was fair to him to have to go and defend himself in this lawsuit in Florida. And so the court said that there were minimum contacts there, even though this man had never been to Florida. There was enough of this business relationship ongoing with the corporation in Florida that Florida had the power to hear this lawsuit brought against the man. In the Asahi Metal case, this is actually a newer case, a little bit newer compared to some of the other ones. The court extended the discussion of this doctrine by talking about what to do when goods are placed into the stream of commerce. And this becomes all the more relevant the more business we do across the internet via delivery service. And the court said, what do you do with a company that is located in one place, has its warehouse and headquarters in that one place, but ships goods all over the country? And this is what they called the stream of commerce. And they looked to see whether placing goods into the stream of commerce and thus knowing that they'll go somewhere else in the country is enough for that company to be subject to be sued somewhere else in the country. And the court ultimately said that placing goods in the stream of commerce is not enough. Sending one item to some purchaser somewhere else in the country does not subject that seller to personal jurisdiction in another state. However, the court did have a few opinions as to the nuances of this doctrine. They didn't reach a majority decision, but there is a plurality in this case. Part of the Supreme Court said placing goods in the stream of commerce with something else, such as advertising, would be enough to subject that seller to personal jurisdiction in other states, while other members of the court said placing goods in the stream of commerce in large quantities is enough to subject that company to personal jurisdiction in other states. As far as states go, some have adopted one of those approaches, and they say you need stream of commerce plus advertising, and other states have adopted the other approach. that says stream of commerce in substantial quantities is enough to satisfy minimum contacts. I'm not going to read the other examples to you, but I hope you can kind of see how nuanced this minimum contacts analysis can be. It's incredibly fact specific. It's highly dependent on the specific facts of a particular case. And it's a dense analysis. There's a lot that the court's going to take into consideration. And you may be wondering, what difference does it make? I mentioned that instance where the family from New York, they could simply refile their lawsuit in New York and bring the lawsuit against the dealership there, rather than bringing the lawsuit in Oklahoma. This often has further implications, and when there's a lot of money on the line, it often does make a difference. Which court has jurisdiction could potentially affect what law applies, and if different states have different laws, some favorable to plaintiffs, some favorable to defendants, which court to file in and which court has jurisdiction can often be a very hotly contested issue. Now, in addition to requiring personal jurisdiction in order for a court to be able to hear a case, a court also has to have subject matter jurisdiction. Subject matter jurisdiction is about whether this is the type of case that a court can hear. Now, in order to explain subject matter jurisdiction, I want to just briefly touch on the different court systems that we have. So in the United States, we have a federal court system. At the bottom of the federal court system are the district courts. These are your trial courts. This is where you would file your lawsuit if you're filing in the federal system. After the trial court, the next highest court in the federal system is the Federal Court of Appeals. These are often referred to as circuit courts. There's a number of circuits, the 6th Circuit, 7th Circuit, 8th Circuit, 9th Circuit. Those are the federal courts of appeals. And then at the top of the federal system is the U.S. Supreme Court. That's the ultimate appellate court. On the other hand, each state also has its own court system. So I live in Michigan, for instance. In Michigan, our trial courts are called district courts and circuit courts. That's where you would file your lawsuit. After that, you would go to the Michigan Court of Appeals. That's our first level appellate court. And then you have the Michigan Supreme Court. So you have two parallel systems. You have the state system and the federal system. So subject matter jurisdiction in this context is looking at whether this is the type of case that can be filed in the federal system. Federal courts are courts of limited jurisdiction, meaning that there are only certain types of cases that they can hear. State courts, on the other hand, have general jurisdiction. State courts can pretty much hear any type of case. Federal courts, you have to prove that this is the type of case that the federal court is allowed to hear before you can file that case or have that case heard in federal court. So when we ask, does the federal court have subject matter jurisdiction, we're asking, is this the type of case that this federal court is allowed to hear? There are 3 types of subject matter jurisdiction. Federal question jurisdiction is the first one. Federal question jurisdiction is present when the lawsuit arises under federal law. So if you have an alleged violation of a federal statute, the plaintiff is suing the defendant saying defendant violated this federal statute. That would confer federal question jurisdiction, meaning that the plaintiff could file that case in federal court. The plaintiff would have to show that the case, the complaint for that case has a federal question on the face of the complaint. This is what we call the well-pled complaint rule. The plaintiff's claim or allegation has to arise from federal law. The plaintiff can't just throw some random federal quote in the complaint and call it a federal question. And in fact, this was the topic of the Louisville versus Nashville Railroad case. In that case, there was a family that had 1 free railroad passes from this railroad company. This was the Motley family. And after they won these free railroad passes, the federal government passed a law that prohibited the railroad from giving out free passes. So unfortunately for the Motleys, the railroad had to take away these passes. So the Motleys sued for breach of contract. Now, breach of contract is a state law claim. There is no federal statute that gives rise to breach of contract. So breach of contract itself is not a federal question. So the Motley's attorney filed the complaint, which alleged breach of contract. And then within the complaint, the attorney also said, and by the way, you can't raise a defense under federal law. You don't have a good claim under this federal law that Congress just passed, and here's why. So they mentioned the federal law, but they mentioned it as a potential defense and argued why it won't work as a defense. They did not include a federal claim. The claim was breach of contract. So therefore, the court ultimately said that that does not meet the well-pled complaint rule. That does not have a federal claim on the face of the complaint. And the federal court does not have federal question jurisdiction over that particular lawsuit. So if there is no subject matter jurisdiction, the Motleys had to go down to state court and they have to file their case against the railroad in state court. Again, this doesn't mean the Motleys are out of luck. They could still file their case. They just put it in the wrong court system. They are allowed to file it in state court. They just can't file it in federal court. The second type of subject matter jurisdiction that the federal court system has is called diversity jurisdiction. This is where you have people who are from different states suing one another. And the reason the federal court system is allowed to hear these types of cases is about fairness to the defendant and the parties. We don't want someone to get essentially a home court advantage in their own state. The federal court system is looked at as more of a neutral playing field. And so when you have people from different states suing each other, rather than having one of their own state's courts hearing the case, which theoretically could give a preference to its own residents, the Constitution recognizes that the federal court system can hear these types of cases under diversity jurisdiction. In order to have diversity jurisdiction, there are two requirements. Number one, you have to have complete diversity. That means that no plaintiff is from the same state as any defendant. So if you have two plaintiffs from Michigan and one from Ohio, that's okay because no plaintiff is from the same state as any defendant. If you had a plaintiff from Michigan and a defendant from Michigan and a defendant from Ohio, then there's no diversity. That would not meet this requirement because you have a plaintiff from Michigan and a defendant from Michigan. You have to have complete diversity. That's the first requirement. And then number two, the amount in controversy, meaning the amount the plaintiff is asking for in damages, has to exceed $75,000. Has to be more than $75,000. So exactly 75 is not enough. But if you have complete diversity and the plaintiff is seeking more than $75,000, then the requirements of diversity jurisdiction are met and the federal court system can hear that particular case. The third type of jurisdiction is supplemental jurisdiction. Now this comes up when you have, first of all, one of those first two. You have either federal question or diversity jurisdiction that gets the parties in the door of the federal court system. And then the parties have additional claims, which on their own would not meet the requirements of federal question or diversity jurisdiction. Either it's a state law issue or it's an issue where the amount in controversy is less than $75,000. Supplemental jurisdiction is the idea that the parties are already here in federal court. We might as well let them bring in these other claims and tackle everything at once because that's a lot more efficient than hearing these claims in federal court and then making them go to state court to litigate the other claims. So for supplemental jurisdiction, the court will hear these claims that on their own would not meet federal question or diversity, but which arise out of a common nucleus of operative fact as those claims which did meet the federal question or diversity requirements. So for instance, if I'm in a car accident and I want to sue both the driver and the owner of the car, and I'm claiming that the driver owes me $100,000 and the owner of the car owes me $20,000. And I'm from Michigan and both of them are from Ohio. Well, as between me and the driver, there's diversity jurisdiction. We have diverse parties, Michigan and Ohio, and we have over $75,000 because I'm suing him for $100,000. With regard to the owner of the car, if I'm just asking for $20,000, I wouldn't have been able to file a lawsuit against the owner of the car in federal court because even though we're diverse parties, I haven't met the amount in controversy requirement. However, because both of my claims against the driver and the owner arise from a single accident, the one car accident, or in other words, they arise from a common nucleus of operative fact, the court will find it to be more efficient for me to just file my one lawsuit against both of them at one time and use supplemental jurisdiction to tack on my claim against the owner of the car. The court is essentially saying, well, since you're here against the driver and you meet the requirements of diversity jurisdiction, we'll let you handle your other claims as well. Go ahead and use supplemental jurisdiction to tack those additional claims on. There's a number of instances where the court could decline jurisdiction. Supplemental jurisdiction does not mean that the court has to exercise jurisdiction over that particular claim or case. The court could say no, thank you. Particularly if there's like a complex issue of state law and the federal court system says, you know what, we could hear this claim because of supplemental jurisdiction. We just think maybe the state should handle it. This is their law. They know more about it. Let's just take a step back and let them deal with it. Or if the state law claim predominates over the claims that the federal court does have jurisdiction over, again, the federal court system could say, look, we could technically hear this claim, but we just think it's better if we take a step back and we let the state deal with that claim. So this is not mandatory. The federal court does not have to exercise supplemental jurisdiction. And in fact, there's a number of instances where they might specifically decline to exercise jurisdiction and just let the state deal with the issues. Removal is the doctrine that applies when a plaintiff files the case in state court and the defendant says, you know what? We could be in federal court right now. This case meets the requirements of either federal question or diversity jurisdiction, and I would rather be in federal court. So the defendant is allowed to remove the case from the state court system over to the federal court system if the defendant can show that the case could have been filed in the federal court to begin with. In other words, the defendant shows that there's either federal question or diversity jurisdiction. If the court disagrees, if the federal court says, no, actually, you should not have removed this case, remand is the term we use when the court sends the case back to the state court system. So a defendant removes the case from state court to federal court, and if the removal was improper or should not have happened, or if the federal court declines to hear the case, the federal court will remand the case back to the state court and just have the state court handle that particular case. Now, once we've established that there is personal jurisdiction over a defendant, and it's fair to the defendant to be sued in a particular state, and subject matter jurisdiction, meaning that this is the type of case that the federal court system can handle, the third question we have to ask here is whether venue is proper. And venue is a matter of whether this is the right court. For instance, in Michigan, I told you that at the federal level, the trial courts are called district courts. In Michigan, we have two district courts. We have the Eastern District of Michigan and the Western District of Michigan. So let's say, for instance, we have a scenario where the state of Michigan has personal jurisdiction over a defendant, and this is an issue involving a federal question. So the federal court system has subject matter jurisdiction over this case. The question of venue looks to see which of those two district courts is the most appropriate place to hear the case. Should that case be filed in the Eastern District of Michigan or the Western District of Michigan? So venue looks to what court to file in. Venue is proper where any defendant resides if all defendants reside in the same state, or where a substantial part of the events or omissions giving rise to the claim occurred. So if the defendant resides in the Eastern District of Michigan, the Eastern District of Michigan would be the appropriate place to hear that case. If the events giving rise to the lawsuit happened in the Western District of Michigan, then the Western District of Michigan would be the appropriate place to hear that case. And there might be more than one proper venue. Let's say that the defendant lives in the Eastern District, but the events happened in the Western District. That means either one of them is a proper venue. It's entirely possible that you have more than one proper venue, and then it's up to the plaintiff to choose which venue to file in. Now, when the plaintiff files and picks a venue, what happens if the plaintiff gets it wrong or if the defendant wants the case to be heard somewhere else? Well, if the plaintiff gets it wrong and files in an improper venue, the defendant can file a motion to transfer to a proper venue. And if the plaintiff files in an inconvenient location and the defendant would simply rather have the case heard elsewhere, the defendant can transfer the case to a more appropriate forum. The final note here is on the doctrine of forum nonconvenience. This applies when a different court system should hear the case. So not necessarily like Eastern District versus Western District of Michigan, but this would be like the plaintiff had filed in Michigan's federal court and the case should be handled in Canada. Or they had filed in federal court and the case should be handled by the state court system. Or let's say they filed in Michigan's court system and the case should be handled by Indiana's court system. It's that a different court system entirely should be handling the case because they're simply better equipped to handle the case. The evidence is located elsewhere. It's more fair to the parties to handle this case elsewhere. And it's asking the court to transfer or just send the case to a different court system. The next issue we have here is on the Erie Doctrine. This is an issue that might come up in a federal court case that is being heard under diversity jurisdiction. So remember, diversity jurisdiction usually happens when you're in federal court on a state law claim, but you're there because the parties are from different states and the amount in controversy is over $75,000. Let's talk about like a breach of contract action, for instance. Let's say that I'm sued in Michigan court, in Michigan's federal court system, for breach of contract by someone who lives outside of Michigan. So there's diversity, the amount in controversy is over $75,000. I'm being sued for a state law claim, breach of contract. The federal court will apply Michigan or whichever state's breach of contract law applies because there is no federal breach of contract law. Breach of contract is a state law claim. However, the federal court in some instances is still going to apply its own law. For instance, there's a set of rules of evidence for the federal courts. There are the federal rules of evidence, and then there are the Michigan rules of evidence. And there might be differences. And the federal rules might allow some evidence in that Michigan would not allow in. So the Erie Doctrine is an issue that comes up as to when do we apply the federal law and when do we apply the state law. So the first step in an Erie analysis is to see if there's even a conflict. If the federal law and the state law say the exact same thing, we don't really have an Erie issue. It's only an issue if there was a conflict. So for instance, the federal rules of evidence would allow this piece of evidence in, and Michigan's rules of evidence would not allow this evidence in. Then there would be a conflict. Step 2 is then to classify the federal law. Where did this federal law come from? Is it a federal rule of civil procedure? Is it a federal statute? Is it a provision of the Constitution? The federal rules of evidence would be akin to the federal rules of civil procedure. If it's not any of these and it's simply federal practice, then you move on to step 3. If it is one of these, then you simply apply the federal law. The federal law here would trump. In step 3, if it's not one of these specific rules, you want to see if the issue is substantive or procedural. The rule is that the federal court will apply the state substantive law and apply its own procedural law. So even though the federal court system is handling this breach of contract issue, they're not going to apply another system's procedural rules. They're still going to follow their own procedural rules. They have to reach out for the state's substantive law on the breach of contract, but they will still apply their own procedural rules. And then finally, the step 4 is to look at some of the different tests that courts apply to determine whether a particular law is substantive or procedural. Some courts, for instance, look at the outcome determinative test. Will applying one law or the other change the outcome of the case? If the answer is yes, that applying a different law will change the outcome, that makes that law look more substantive than procedural. So they're more likely to apply the state law version of the law. You could also use the balancing interest test. Balance the interest of the federal government against the state government and ask who has a stronger interest in having their law applied. You can also look for forum shopping. Is someone just forum shopping or trying to pick the most beneficial law by filing where they filed their lawsuit? And if that's the case, then the court would likely go ahead and apply the state law to that particular issue. The next topic that we have for civil procedure is claim and issue preclusion. And this is actually the end of our case-based analysis of civil procedure. The idea behind claim and issue preclusion is that we want judgments of the court system to be final and binding. If they're unsettled and there's never any finality to them, they don't really mean anything. Imagine, for instance, that you file a lawsuit against someone because they were negligent driving their car, they hit you, you had damages. You sue them for damages and you get an award of $100,000. We want that person to know that this is it. The lawsuit's over. They shouldn't walk around in fear that you're going to sue them again and again and again and again. So claim and issue preclusion makes judgments binding. Once something has been litigated and you got your day in court, that's it. You don't get another chance to relitigate the same thing again. Claim preclusion has 4 elements. We're talking about when we have the same claim, the same parties that reached a final judgment on the merits. So for instance, you sue that other driver for negligence arising out of a car accident. You get a final judgment where you're awarded $100,000 and it was decided on the merits. Let's say this was decided via a jury trial. 3 years later, you say, you know what? I think I could have gotten more money. I'm going to sue that person again. And you file another lawsuit against that same driver arising out of the same car accident for negligence again. It's the same claim. You have the same plaintiff and defendant, same parties. You already had a final judgment, and your final judgment was made on the merits. Because all of the elements are met, you will be precluded from filing that second lawsuit. So this is a defense that the defendant would raise. So when you sue that driver in lawsuit number 2, the driver is going to respond to your complaint and answer it raising claim preclusion. They're going to say, this plaintiff is barred from relitigating this lawsuit. We've already handled this. They cannot bring another claim against me. And again, it's for fairness to that person. We don't want them walking around for the rest of their lives, wondering when they're just going to get sued again. We want them to know that once they've been sued, once the issue's been litigated, once we have a final judgment, that's it. They can be confident that this is a settled matter. Issue preclusion, on the other hand, doesn't necessarily have to be a claim, like a legal claim. I always think of issue preclusion and more as like an argument. When you have an argument that's been hashed out, we've come to a decision, and it was a big argument, that's where necessary comes in. It was something that was crucial to the overall litigation. We're not going to have that same argument again. So let's say, for instance, that my employer tells me that I am not entitled to any type of insurance benefits because I'm not an employer. I'm an independent contractor. And I sue them for not providing me the insurance benefits. And we litigate this issue of whether I'm an employee or an independent contractor. And the court decides I'm an independent contractor. And so they throw my lawsuit out. 2 years later, I sue that same employer for something else entirely. Let's say I sue them for breach of contract, and the breach of contract claim turns on whether I'm a employee or an independent contractor. The employer can raise issue preclusion, and the employer can say, Heather, we're not going to litigate this argument again. We're not going to argue about whether you're an employee or an independent contractor. We already reached a decision here. The court said you're an independent contractor. So it's like an argument that underlies the claim. And once it's been fully litigated, the court's not going to let the parties litigate it again. So when you have the same issue, independent contractor versus employee, actually litigated, we argued about it in lawsuit number 1, actually decided, the court ruled on it, and necessary to the litigation, then the issue will be precluded in lawsuit number 2. And when we say necessary, what I mean by necessary is that this is something that we know actually went into that final decision in the first lawsuit. So if a jury, for instance, had ruled that lawsuit dismissed because Heather is an independent contractor and they specifically identify that as the reason for their decision, then we know that the independent contractor analysis was necessary for the decision. Versus if the jury just says, lawsuit dismissed, we don't believe Heather. We don't know how they reached that conclusion. So we don't know if the discussion was necessary to the jury's decision there. So it had to have been something that was necessary to the jury's decision in order to be precluded later on. Okay, so as I said, that takes us through the case law-based portion of civil procedure. So the second half of civil procedure, or the first, depending on how your school presents it, is based on the federal rules of civil procedure. This is a big book of rules, and each rule pertains to some piece or portion of the civil litigation that is taking place in the federal court system. So the first set of rules we have here are the pretrial procedures, and these dictate how, what, and when to file your lawsuit. Jurisdiction tells us where to file, so we already know where we're allowed to file based on that discussion. Here, this is the how. What are we putting together? How are we going to file it? Things like that. First of all, we have rules regarding the complaint and the answer. These are considered pleadings. And you'll notice in purple font that the number of the rule is identified after the sentence. This will likely come in handy when you're in civil procedure class. And as your professor will likely expect you to know the various rule numbers and what rule follows from it. But here I really just want to go over an explanation of the various rules, so I'm not necessarily going to focus on too many of the numbers. So the complaint and the answer are your initial pleadings. The plaintiff files what we call a complaint, setting out the facts and allegations sufficient to put the adversary, the defendant, on notice of plausible claims. So the defendant has to know from the complaint what they're being sued for. This doesn't have to be terribly particular. It's very likely that at this point, the plaintiff doesn't know the details of the case. But if the plaintiff is suing for something like fraud has to be stated with particularity. As far as the timing goes, the plaintiff will file the complaint with the court system. You tell the court first that you're bringing the lawsuit. And once it's been filed with the court, the plaintiff has 90 days to serve the defendant. And Federal Rules of Civil Procedure 4 is the rule that deals with service of process. It tells you how, who, when, what to serve on the defendant to let the defendant know that they've been sued. Once they've been served, the defendant has 21 days to respond to the complaint or to file their answer. If the defendant waives formal service, they get a little bit more time. They get 60 days to file an answer instead. Very importantly, a pleading can be amended without the court's consent. If a party realizes that there was a mistake or they need to make a change to that pleading, they're allowed to file an amended pleading within 21 days after serving that pleading. They don't need anyone's permission to do so. They can amend it as a matter of right. Now, that only applies to pleadings, though. So motions cannot be amended, but pleadings can. With regard to joinder of claims and parties, this is an issue when you have multiple people being sued or multiple claims to bring against someone. When can you bring all of those claims or people in one lawsuit? And when do you have to file separate lawsuits? So first of all, joinder of new claims says once a party has brought a claim against another person, it can tack on any other claims it has against that person, even if they're unrelated. So if I sue someone for negligence arising out of a car accident and I have a totally unrelated breach of contract claim, I could bring them together. Assuming that there is sufficient subject matter jurisdiction, I could tack those claims together for the purpose of efficiency. Why bring two lawsuits? We're already here. We're in court. Let's just deal with everything as much as we can in one lawsuit. A counterclaim is where the defendant says, you're going to sue me? I've got a claim against you too. And the defendant turns around and files a claim against the plaintiff. So the plaintiff started the lawsuit and threw the first punch. The counterclaim is the defendant punching back. Under the federal system, there are what we call compulsory counterclaims, meaning that if the counterclaim arises from the same transaction or occurrence, the defendant must bring it. So if I sue someone for negligence arising out of a car accident and they want to claim actually I was the one who was negligent, they must bring that claim against me in the same lawsuit. They can't file their own separate lawsuit. That makes it a compulsory counterclaim. A cross claim is a claim that's on one side of the V. So either a plaintiff suing a plaintiff or a defendant suing a defendant. It's a counterclaim if it crosses the V. So if a defendant sues a plaintiff, that's a counterclaim. But if a defendant number one sues defendant number two, that's a cross claim. Joinder of parties discusses when it's permissible for parties to be joined together in a single lawsuit. Plaintiffs are allowed to bring other plaintiffs into the lawsuit as long as they're asserting a right to relief jointly, severally, or in the alternative with regard to claims that arise from the same transaction or occurrence. So if my friend and I are in a car together and we get into a car accident, we could join together and bring one lawsuit against the other driver. That's two plaintiffs joining together. Same thing works for defendants. If I want to sue the other driver and the owner of the other vehicle, two different people, I could bring one lawsuit against those two people. Intervention is a tool that outside third parties will use when they hear about a lawsuit and they say, you know what? I have an interest in that lawsuit. I want the court to hear my side of the story too. So they file a motion to intervene in the lawsuit, usually as a plaintiff. So intervention is proper as a matter of right, meaning that the court cannot say no if the party that hears about the lawsuit has an interest in the lawsuit that is not currently adequately protected. So someone is worried that the current parties are not going to protect their interest. They say, we have to come into this lawsuit. We have to argue our side of the story. We have to make sure the court hears everything to make a proper decision. Even if they can't show that, they may be able to intervene permissively, which the court just has discretion over and tends to be a matter of timing. As long as it's not going to delay the lawsuit too much, the court should grant a party the right to intervene permissively. Interpleader is kind of an odd concept. This doesn't come up too much in practice. Interpleader is where someone who's holding property, usually like a finite amount of property, brings a lawsuit against all the people who could potentially file a claim for that property. And they are the plaintiff, and they essentially say, I have this much property. You defendant have to make the argument for how much you're entitled to. This could come up, for instance, if you had like an insurance payout and the insurance policy only went up to a certain dollar point. So let's say there's $100,000 available and 10 claimants. The insurance company could sue the 10 claimants rather than sitting back and waiting to be sued 10 different times. And they could use this interpleader tool to file their lawsuit. Finally, we have class actions as a means of starting a lawsuit. A class action is proper where you have so many people joining together in a single lawsuit that it makes more sense to file it as a class action than to have 100 or 200, however many number it is, of individual named plaintiffs, each with their own attorney, each with their own complaint, each with their own set of facts and damages and arguments. A class action is appropriate where one person represents all of those members of the class and they file a single lawsuit against the defendants. The Federal Rules of Civil Procedure identify several factors that have to be met for a class action to be appropriate. We look at commonality. So how common are the issues between the members of the class? Adequacy. Does the class representative adequately represent the class? Numerosity. How many people are we talking about? Typicality. Is the claim of the named plaintiff typical of the class? And superiority. Is a class action the superior method for litigating this type of thing? Preliminary measures are covered in the Rules of Civil Procedure as well. These are the measures such as temporary restraining orders and preliminary injunctions. These are tools the court can use before a full trial can be had to kind of keep things in place, to maintain the status quo before the case is fully and finally litigated via a full trial. The Federal Rules of Civil Procedure also lay out the structure and the schedule for discovery in civil lawsuits. Under the Federal Rules of Civil Procedure, parties can discover anything that is relevant and not privileged, meaning that discovery is very, very broad. Discovery is the process by which the parties get all of their evidence. And the Rules of Civil Procedure lay out a number of tools that the parties can use for discovery. So for instance, they can use things like interrogatories. This is a set of questions that one party will send the other party and say, answer these questions, I need this information. They could use requests for production of documents. They could use subpoenas to require someone to show up or to produce something. So the rules identify a number of tools that the parties can use to gather this evidence that they need for their lawsuit. The discovery rules in the Federal Rules of Civil Procedure also lay out a timeline and a structure that the court uses to make sure that everyone stays on track. In these really big lawsuits, it's very easy for parties to get carried away with discovery. And the court wants to make sure that the things keep moving nicely and things are progressing in the lawsuit. So there's a number of conferences and requirements where the parties have to turn over their discovery or let the court know what's happening with discovery so that the court can make sure that the parties are still on track. I mentioned that we would come back to the idea of service of process, and that's listed here in this middle box. This is Rule 4 of the Federal Rules of Civil Procedure. Service of process is where the plaintiff gives the defendant notice that he or she is being sued. So they give them a copy of the summons and the complaint. The complaint is the document the plaintiff drafts that says, here are my allegations against you. The summons is the document that tells them what court they're in, who the judge is, when they have to show up, what time they have to show up, things like that. It's more of the practical aspects of litigation. So service requires the defendant to be served with the summons and the complaint. the person serving the summons and the complaint actually can't be the party. So a plaintiff can't serve his or her own summons and complaint. The plaintiff would have to hire someone. This is who we would call a process server to serve the summons and complaint on the defendant. And the person serving has to be over 18. So over 18 and not a party are the requirements that you have to meet to be able to serve process. So how does one serve process? There's 4 methods that could be used. Number 1, you can follow any method that the state allows. So even if you're in federal court, look to the state where that federal court is located. You can use any of that state's methods for serving process. Number 2, you could serve on the agent. So if a corporation has designated a resident agent to accept process, the plaintiff could serve the process to that agent. Number 3, you can serve an individual. If I'm being sued, the process server could just walk up to me and say, here you go, here's the summons and complaint. And number 4 is a dwelling. You can leave a copy of the summons and complaint at the person's dwelling with someone of suitable age and discretion who lives there. You can't simply tack it on their door. You have to hand it to someone, but you can leave it with someone at their person's dwelling. A corporation can be sued by any of those any state law method as well, or the corporation could be sued via an officer, managing partner, general agent, or anyone authorized to receive service on behalf of the corporation. And then if the defendant waives formal service, we talked about this before, they get the benefit of a little extra time to answer the complaint. Now, when they're waiving service, they're not waiving service altogether. They're just waiving formal service. So it might be something to the effect of, hey, I know you're suing me. Go ahead and mail me a copy of the summons and complaint. I'll waive formal service. You don't have to hire a process server. I'll accept it via mail. And then they get the benefit of that additional time to answer the complaint. The next section on motions actually provides a really great timeline for what happens in the course of a lawsuit. So a lawsuit is started when the plaintiff files the complaint. And then at the top, you'll see the red boxes. The next step in a lawsuit is for the defendant to file an answer or a motion. Before they do that, if you look at the gray box between the complaint and the answer, the defendant can bring some types of motions. They can bring a motion for a more definite statement or a motion to strike. These would be appropriate before filing an answer, arguing that there is a problem with the plaintiff's complaint. Either it's not clear enough and the defendant needs more information about the allegations, or there's some inappropriate information in the complaint that should be stricken from the complaint. They could bring this before filing an answer. Let's say they choose not to do that though. Let's say they just go ahead and file their answer or their motion. In their first answer or motion, there are certain things that must be raised. And if they don't raise these arguments in that first answer or motion, they're gone forever. They've essentially consented to these issues. And those include lack of personal jurisdiction, insufficient process, wrong venue, and any affirmative defenses. Claim preclusion, for example, is an affirmative defense. So this is where the defendant would raise claim preclusion and say, hold on a minute, you can't bring this lawsuit again. It's barred by claim preclusion. If they don't raise these arguments at this time, these arguments are waived and they're gone forever. They have essentially consented to them. After they file that motion, this is the point at which we do all that discovery. There's a lot of little motions going back and forth. There's a number of motions that could be brought in here. This is the gray box underneath the red trial box. So any time between the answer and trial, parties can bring motions such as failure to join necessary parties. So in other words, there's other people we need to fully litigate this lawsuit. They could seek judgment on the pleadings. We'll talk about that in just a second. Or they could assert any type of failure to state a valid claim or defense. Again, we'll talk about that in just a second. Then we have the trial. And then after the trial has occurred, or really any time, the other type of motion we have is lack of subject matter jurisdiction. Remember, subject matter jurisdiction is the power of the federal court to hear this type of case. If the court doesn't have the power to hear the case, they can't hear the case, no matter when that argument is raised, even if it's raised for the first time on appeal. So there is no consenting to subject matter jurisdiction of the court. It's not something that can be consented to. So you can raise this argument through a motion at any time at all. This gray box discussing motions for summary judgment and Federal Rule of Civil Procedure 12b-6 motions, these are the motions on the pleadings that I mentioned where the party is seeking judgment on the pleadings. In either one of these instances, a party would bring this motion arguing there's no point in us going to trial. We don't need a jury to hear this case because you, judge, can hear this case based on the pleadings. You can look at the papers in front of you and you can issue a final decision in this case. A motion for summary judgment is appropriate if the party filing the motion, making the argument, can show that there's no genuine issue of material fact. In other words, there's nothing for the jury to decide. All of the facts are incredibly clear based on the evidence we have. So when that's the case, you're asking the judge to issue judgment in your favor when you file this motion. The 12b-6 motion, this is failure to state a claim upon which relief can be granted, looks at the pleadings themselves and the allegations. So in this instance, the moving party is saying they haven't effectively asserted a good claim. They haven't shown that they're entitled to anything. Therefore, judgment is proper because they haven't stated a claim upon which relief can be granted. So these could be considered pre-trial motions. Any time before the trial, the parties could file a motion for summary judgment, asking for a ruling on the pleadings, or failure to state a claim. The second to last section we have here is on trial motions. Now, these have a similar idea to like a summary judgment or failure to state a claim motion, except that the timing is different. These motions occur during the trial, once the trial has already occurred. The first one we have here is judgment as a matter of law. I want to first look at the timing of it. When would you file this type of motion? Well, this is in the middle of trial, and the defendant can either file the motion after the plaintiff has presented his or her evidence. The defendant can just say, you just saw their evidence, it's not enough, I'm entitled to judgment. Or the defendant could present their own evidence and then file this motion and say, you heard the plaintiff's evidence, you heard my evidence, clearly my evidence was better, please give me judgment on the merits. And you're essentially asking the judge in the middle of trial to rule in your favor and not continue and send the case off to the jury. The plaintiff can also file this type of motion. The plaintiff simply has to wait until the defendant is done presenting his or her evidence before the plaintiff can file. And this motion should be granted if the moving party can show that there's no substantial evidence to support a verdict for the non-moving party. So based on what evidence was just presented at the trial, you're saying there's no way the other guy could possibly win. So let's not waste the jury's time. Let's just rule in my favor right now. Let's say the judge denies that motion and the judge sends the case to the jury and the jury renders a verdict and you don't like the verdict. One of the parties is going to be upset by the verdict that the jury comes back with. That party can file a renewed judgment as a matter of law motion. So here, after the jury's verdict, this is filed within 28 days of the jury's verdict, the party filing this motion argues that the evidence was insufficient as a matter of law to support the jury's verdict. So you're saying to the judge, throw out the jury's verdict. That was wrong. They got it dead wrong, and change it and rule in my favor. So same idea, you're asking the judge to enter judgment in your favor, but the timing is different. This is after the jury has already returned a verdict. As I'm sure you can imagine, this is a very hard motion to win. At the same time you file your motion for renewed judgment as a matter of law, you can also ask the court for a new trial. So here you can either argue that the verdict was against the great weight of the evidence, or that there was some sort of trial error, and as a result of that, a new trial is warranted. This is a little easier for the judge to kind of swallow than a renewed judgment as a matter of law, because the judge is more likely to say, okay, we'll try again, and give you a new trial than to say, you're right, they got it dead wrong. Here's judgment in your favor instead. So here they basically redo the whole thing. The next one is a motion for relief from judgment. These are pretty hard to win. You have up to a year, sometimes longer if justice dictates, to file this type of motion. This is appropriate if something comes to light after the fact that could not have been discovered during the trial. So for instance, you find out that someone committed fraud in discovery, or you find some new evidence that you never could have found during the course of the trial. You have up to a year to file a motion for relief from judgment. And then finally, your last option to contest a jury's verdict is appeal. 30 days after entry of the judgment at the trial court level, the losing party can appeal that trial court's decision. However, certain things can be appealed right away, where they don't have to wait for that final entry of judgment, such as preliminary injunctions. But usually you have to wait until the trial court enters a final order before filing your request to appeal. Just a few final notes on jury trials and some of the rules regarding jury trials under the Federal Rules of Civil Procedure. The Seventh Amendment of the Constitution protects the right to a jury trial and dictates that the jury pool must come from a cross-section of the community. That means the people who are called to jury duty. So if you've ever had jury duty and you sit in a room with like 200 people, that's the jury pool. That jury pool has to represent the community. If from that jury pool, they pick 12 white females to sit on the jury, there's nothing wrong with that as long as those 12 white females were properly selected from a diverse jury pool. A party has to request a jury trial. You don't automatically get a jury trial. You have to file a request, and you have to file this within 14 days of service of the complaint. So you have to let the court know right up front, we want a jury trial. So what usually happens is most people will simply file the request at that appropriate time. So even if they change their mind later on and don't want one, they did their due diligence by filing the request up front. A jury for a civil case has to begin with at least 6 people, but can't have more than 12. Sometimes the court will select alternates just in case 1 or 2 jury members fall off. And typically the decision of the jury has to be unanimous, and it has to be decided by at least 6. So if you start with, let's say 10, but it's a really long trial, so 4 fall off, and you end with 6 jurors, you can have a valid decision from 6 jurors as long as it's unanimous. At the close of evidence, a party is allowed to file and furnish to every other party written requests for jury instructions. So you tell the judge what you want the judge to instruct the jury on. And on appeal, if you had a jury trial, the appellate court can only consider plain errors in the instructions, even if those have not been properly preserved or objected to. So the appellate court will look at those jury instructions that the judge read to the jurors and see if there was any plain error that would justify reversing the jury's decision and sending the case back down to the lower court for a new trial. So I know this has been a lot of rules and a lot of dense information about civil procedure, but I hope you find this class interesting. I definitely liked it. I liked all the rules and the structure that it provides with regard to litigation. I know it can be hard to wrap your head around all of this information, especially if you don't have much context to apply it to, but I really hope you find this information in this class enjoyable.